The Supreme Court just changed everything, and they hoped you'd sleep through it. 7 justices of the United States Supreme Court issued an emergency ruling in the middle of the night, a 7-2 decision that legal scholars are already calling one of the most consequential structural rulings in a generation. And you woke up the next morning, poured your coffee, scrolled your feed, and most of you had absolutely no idea it happened. Think about what that means. The highest court in the land, 9 people with more concentrated legal power than anyone else in this country, issued an emergency order that will reshape how laws are made, challenged, blocked, and enforced across all 50 states for every single American alive today. And the story didn't lead the news, it didn't dominate the morning shows, it got swallowed whole by celebrity gossip, partisan theater, and the daily manufactured noise machine that exists for one purpose: to keep you distracted from the decisions that actually determine the shape of your life. This is the Supreme Court's 7-2 emergency ruling on nationwide injunctions. And right here, right now, I'm going to tell you exactly what happened, why it matters, and who was desperately hoping you'd never fully understand it. If you've been looking for a channel that refuses to let the stories that actually matter get buried under the noise, subscribe right now. Hit that button before we go any further, because what I'm about to walk you through is the kind of reporting that disappears fast. And you deserve to know what is happening to the country you live in and the system that governs your life. The weapon nobody wants to admit they used. Here's the truth that official Washington has spent years, decades even, carefully avoiding any honest public conversation about. Nationwide injunctions stopped being a legal instrument a long time ago. They became a weapon, a loaded, ready-to-fire, shameless, bipartisan weapon that both political parties reach for without hesitation every single time the democratic process produced a result they didn't like. And the mechanics of that weapon were so breathtakingly simple that it almost defies belief, which is exactly why it worked for so long and did so much damage to the foundational structure of American self-governance. Here's how it worked. Your side loses in Congress. Your party couldn't build a coalition, couldn't convince enough of your colleagues, couldn't persuade enough of the public. The legislative process, messy, slow, demanding, contentious, exactly as the founders designed it to be, produced an outcome your side found unacceptable, so you didn't accept it. You picked up the phone, called your lawyers, and asked them one question: which federal district court is most likely to rule in our favor? That's it. That was the entire strategy. Find the right jurisdiction, find the sympathetic judge, file the lawsuit, get the injunction, and suddenly one single unelected federal judge sitting in one city in one corner of this enormous, complex, diverse nation of 330 million people has just frozen a law. Frozen in executive action, frozen as state policy for everyone. All of it based entirely on a lawsuit brought by a handful of plaintiffs who may bear no meaningful resemblance to the broader population now living under that judge's order. That is not how the Constitution was written. That is not how American democracy was designed to function. That is not the system that generation after generation of Americans were told they were living under when they were asked to trust their institutions, follow their laws, and believe that the system, however imperfect, was fundamentally legitimate. So what they were actually getting was something else entirely, a system where national policy could be determined not by elections, not by legislation, not by any democratic process of any kind, but by whoever had the best lawyers and the most money and the tactical sophistication to file in the right zip code at the right moment. And here's what should make your blood run cold. Regardless of your politics, regardless of your party, regardless of which side of any given policy debate you happen to stand on. Everybody knew it. Every serious legal scholar who spent time thinking about judicial power and constitutional structure knew the system was broken. Every federal judge paying honest attention knew it. Every attorney general who has filed one of these nationwide injunctions while simultaneously screaming about judicial overreach when the other side did the exact same thing, they knew it too. Every single one of them, they kept using it anyway, because winning felt better than fixing it, because the shortcut was right there, and because the people being harmed most by the dysfunction were ordinary Americans, who had no idea the game was even being played at this level. The Supreme Court of the United States just looked at all of that and decided the problem can no longer be ignored. What actually triggered the emergency? To understand why this ruling came down as an emergency order, not after months of oral argument, not after a full and deliberate briefing schedule, not through the patient, measured process that usually characterizes major Supreme Court decisions. You have to understand what was actually unfolding on the ground in the weeks and months leading up to it, because this didn't come out of nowhere. This came out of a pattern that was escalating, accelerating, and threatening to spiral into a full-scale constitutional crisis that the court apparently decided it could not allow to fully materialize. Multiple states had gone to federal court, raising serious, substantive constitutional challenges to what they described as a sustained and accelerating pattern of federal overreach. And these weren't fringe actors. These weren't conspiracy theorists or political provocateurs looking for attention. These were sitting governors, state attorneys general, state legislators, duly elected representatives of state governments, accountable to their voters, who stood up and said clearly and on the record that the federal government is operating outside the boundaries the Constitution draws around its authority. And they argued that federal agencies were issuing rules and directives under the cover of emergency powers and executive authority that effectively rewrote state law without any legislative mandate, without any democratic vote, without any meaningful accountability to the people being governed. And most directly affected, those are serious claims. They are the kind of claims that deserve serious engagement, serious legal analysis, and a serious institutional response. What the states got instead was the very thing they were complaining about, delivered with extra force. Lower federal courts, the district courts and circuit courts that sit below the Supreme Court, responded to these state constitutional challenges by issuing nationwide injunctions against the state laws themselves. Read that again, because it deserves to sit with you for a moment. States went to court arguing that the federal government is overstepping its constitutional authority, and the federal court system responded by using its own sweeping authority to block the state laws nationwide before they had even fully gone into effect. The federal judiciary, rather than acting as an independent check on executive power the way the constitutional design demands, was functioning as an extension of that executive power, using the blunt instrument of nationwide injunctions to neutralize democratic state governance before it could be meaningfully evaluated on its merits. The Supreme Court saw exactly what was happening. That is why the order came at night. That is why it was classified as an emergency, because what the justices were witnessing wasn't an isolated mistake by one overzealous district court judge having a bad day. It was a pattern, a normalized, almost reflexive institutional habit of lower courts issuing sweeping national blocks that bore no proportional relationship to the actual legal injuries suffered by the actual plaintiffs in any given case. The court had tried to signal its concern before, most explicitly in Labrador v. Poe, where similar limits on the scope of lower court power were sketched out. The signals weren't enough. The practice continued and escalated and pushed further. And so 7 justices did what they do only in situations of genuine constitutional urgency. They issued an emergency order that changed the rules of the game for every federal court in America overnight, without waiting for permission from anyone. What the justices actually said. Now let's get to what the justices themselves actually wrote, because the language coming out of this ruling is not the dry, hedged, carefully passive legal boilerplate that usually makes Supreme Court opinions feel like they're written specifically to be misunderstood by everyone outside of law school. This language is pointed, it is direct. In some cases, it reads like a justice who has been holding something back for years. And finally, with this moment, decided the time had come to say it plainly and put it on the record permanently. Justice Neil Gorsuch wrote a concurring opinion, meaning he agreed with the majority decision but wanted to put his own specific reasoning on the record separately, which is itself significant because it signals he felt the majority opinion alone. Ab wasn't strong enough to say everything that needed saying, and the central phrase he used has already become one of the defining legal statements of 2026. Gorsuch wrote that lower federal courts issuing sweeping nationwide injunctions are acting like, in his words, many legislators read that again and let it land. A sitting justice of the United States Supreme Court looked at the behavior of federal district court judges, unelected, unaccountable, appointed for life, and stated in an official written opinion that they are not functioning as judges. They are functioning as lawmakers, unelected lawmakers. Lawmakers accountable to no constituency, to no election, to no democratic process of any kind, imposing national policy outcomes on the entire country based on lawsuits brought by small groups of plaintiffs in single jurisdictions who may bear no meaningful resemblance to the hundreds of millions of people now forced to live under the resulting order. Gorsuch went further, arguing that courts must return to what he described as the traditional limits of equitable relief, the long-established legal principle that a court's remedy must be proportional to the actual injury suffered by the actual party standing before that court. The logic is foundational and it is not complicated. If someone hurts one person, a judge can order that person to stop being hurt. The judge cannot, based on that one person's lawsuit, ban the behavior in question for 330 million people who were never part of the case, who never had standing, and who may be living in circumstances entirely different from the plaintiff whose injuries supposedly justify the order. That is not justice. That is policy. And policy in a constitutional democracy belongs to the branches of government that are actually answerable to the people who have to live under it. Justice Sonia Sotomayor, one of the two dissenters, raised a counter-argument that deserves honest engagement rather than dismissal, because her concern is real and it is grounded in practical legal reality. If injunctive relief can only protect the specific plaintiffs who filed a particular lawsuit, you risk ending up with a fractured legal landscape where the same federal law is enforceable in 20 states and blocked in 30 where your rights under a federal ruling depend entirely on whether you happen to be a named party in that specific litigation. Unequal enforcement. Inconsistent legal realities for people living under the same federal government. These are legitimate concerns and they point to real complications in implementation, but here's why the majority wasn't persuaded and why I believe they were right to hold the line, even knowing the short-term turbulence is real and unavoidable. The system Sotomayor is defending, the world of sweeping nationwide injunctions, doesn't actually solve the inequality problem. It relocates it. It creates a different and in many ways more corrosive inequality, one where national policy is determined not by elections or legislation, but by which side had better lawyers, more money, and the tactical sophistication to file in the most favorable zip code. And that is not justice either. And the majority made the harder, more honest choice. How this hits your actual life, this is where it stops being an abstract legal debate and starts being about your paycheck, your family, your community, and the policies that determine what is possible in the state where you live. So let's be specific. Let's be concrete. Let's talk about what this ruling actually changes for ordinary Americans across the full range of policy fights that have defined the past decade of American political life. Start with immigration. Because immigration has been the single most litigated policy arena in American politics for years, and nationwide injunctions have been the weapon of choice for every administration that found itself losing a particular battle in court. Under Donald Trump's first term, travel ban policies were frozen by nationwide injunctions issued by district court judges within days of executive orders being signed, sometimes within hours. Under Joe Biden, immigration enforcement priorities were similarly blocked by nationwide injunctions coming from the opposite direction. The result was years of whiplash, legal chaos, and policy paralysis that served nobody well. Not the people seeking legal status, not the communities trying to plan around enforcement realities, not the agencies trying to execute coherent policy, not because the underlying constitutional questions weren't serious or worthy of judicial attention, but because both sides found it more tactically effective to shop for sympathetic judges than to do the grinding, difficult, politically costly work of building durable legislative solutions. Under the framework the Supreme Court just established, that dynamic becomes significantly harder to execute. A single court order triggered by plaintiffs with no direct connection to a specific state's particular circumstances cannot freeze that state's entire enforcement apparatus. The fight moves to where it always should have been, to Congress, to negotiation, to the hard work of actual governance. Move to guns, because the consequences here are immediate and concrete, regardless of where you stand on the underlying policy debate. Multiple states in recent years passed significant gun safety legislation, expanded background checks, assault weapons restrictions, red flag laws designed to keep firearms out of the hands of people actively in crisis. And in case after case, those democratically enacted laws were challenged in federal court and hit with nationwide injunctions that froze them, not just in the state that passed them, but across the board, based on lawsuits filed in jurisdictions chosen specifically for their likely outcomes. That dynamic just changed in a fundamental way. A state that passes a gun law now has meaningful runway to actually enforce. It's while legal challenges work their way through the normal judicial process, that is not a guarantee of any particular outcome. Courts can still strike down unconstitutional laws, but it means the process plays out on honest terms rather than being short-circuited before it begins. Election law is the most politically volatile arena this ruling touches, because election law sits at the intersection of constitutional rights, partisan interest, and the most fundamental question of democratic governance: who gets to vote? On what terms? Under what conditions? Nationwide injunctions have been used aggressively and repeatedly in election disputes. Voter ID requirements, absentee ballot regulations, redistricting challenges, early voting rules, with each side seeking broad national blocks whenever a ruling seemed likely to go their direction. The Supreme Court's ruling makes it dramatically harder to use a single lawsuit to freeze election rules nationwide, which means election policy is going to have to be contested where it was always supposed to be contested: in state legislatures, in Congress, and ultimately at the ballot box in front of the voters who actually have to live with the results. And for those who care about environmental protection, and you should, because the consequences of regulatory failure in this area are multi-generational and irreversible, this ruling hits in ways so the environmental community is only beginning to fully process clean power regulations, methane emission rules, water quality standards, endangered species protections. All of these have at various points been paralyzed by nationwide injunctions. If you've been relying on federal courts to enforce environmental standards that Congress won't codify and state legislators won't protect, that strategy just became significantly less reliable. The fight moves to legislatures. That means it moves to elections, which means it moves to you. The political fallout and the hypocrisy exposed. This is where I need you to stay with me, because the political fallout from this ruling is unfolding in real time, and the way different institutions are responding tells you everything you need to know about who actually benefited from the old, broken system and who is scrambling to figure out how to survive without it. The White House and the Department of Justice released what I can only describe as carefully managed non-statements in the same hours after the ruling came down. Not outrage, not celebration, not even a coherent policy position. Language along the lines of having reviewed the court's order and assessing its implications. That is the language of an institution that took a significant institutional hit and is trying to figure out how to absorb it without publicly admitting how badly it stings and how much it costs them. Inside the DOJ, according to people who work there, officials were using one word privately to describe this ruling: earthquake. Not a setback, not a complication, an earthquake. Because what the Supreme Court just did is not a procedural tweak that can be managed around the edges with creative legal argumentation. It is a structural shift in how the federal government can use the judiciary to advance its policy agenda. And the federal government's lawyers understand exactly what that means for the decades of strategy that have now been fundamentally disrupted. Meanwhile, on the other side of the fight, state attorneys general weren't waiting for anyone's permission to respond. Within hours of the ruling coming down, AGs from multiple states had already filed supplemental legal briefs in ongoing cases, citing this Supreme Court decision as direct authority for their arguments against federal overreach. These legal teams had been watching for exactly this kind of ruling. They were ready. They moved the moment it landed. And that tells you something important, that for at least some of the actors in this fight, this ruling was not a surprise. It was the answer to a question that serious constitutional lawyers have been asking for years about whether the system could correct itself before it completely broke down. Now, here is the hypocrisy that needs to be called out plainly, without partisan softening, without the false balance that treats unequal behavior as if it were somehow symmetrical. Because both sides are guilty of this. Both sides deserve to hear it said directly and without the usual hedging. This ruling does not favor one party. It does not entrench one ideology. It does not hand a permanent advantage to conservatives or progressives or anyone else. It changes the rules for everyone equally, permanently. And the reason that matters, the reason it needs to be stated this clearly, is that both parties spent years, enthusiastically and without apparent shame, using nationwide injunctions as a substitute for governance. When Democrats controlled the White House, it was Republican state attorneys general filing for nationwide injunctions too. Freeze progressive federal regulations. When Republicans controlled the White House, it was Democratic state attorneys general filing for the exact same nationwide injunctions to freeze conservative federal policies. Every single one of them called it constitutional principle when they were the ones filing. Every single one of them called it judicial overreach when the other side was filing the identical type of motion in an act. identical type of court. The cynicism of that position is staggering. The damage it did to public trust in institutions is real and lasting. And the Supreme Court just told all of them the same thing, without distinction and without apology. You do not get to manufacture national policy outcomes by finding the right judge in the right zip code. If you want to govern this country, go win elections. If you want to make law, go pass legislation. Go do the actual, difficult, accountable work of democracy. That message applies equally to every political actor in Washington right now. And the fury it is generating in certain quarters tells you exactly how much certain people were. Depending on the shortcut this court just eliminated, where this goes and what it demands of you. So where does this actually go from here? What does the road ahead look like for American law, for American politics, for the ordinary person trying to figure out how a Supreme Court emergency ruling in the middle of the night translates into the daily reality of their life? The first thing to understand is that this was an emergency order, not a final comprehensive merits opinion. The underlying cases go back to the lower courts, which must now apply the new and significantly narrower framework to the actual disputes at hand. And those lower courts will be doing that work under a level of scrutiny they have not faced in years. Because every federal judge in this country now knows that the Supreme Court is watching and that a sweeping nationwide injunction issued without rigorous, specific, case-by-case justification is going to get reversed quickly, publicly, and decisively. The federal government will push back. It will find test cases where it can argue the national interest is compelling enough to justify broader relief even within the new framework. There will be circuit splits, situations where different federal appellate courts interpret the new standard in contradictory ways, and those splits will eventually force the Supreme Court back in with a full merits decision that settles the question with even more specificity and permanence. This is the beginning of a long legal recalibration, not the final chapter of the story. The road ahead is going to be complicated, contentious, and at times deeply frustrating for people on every side of every policy debate. Before we go further, if you've been watching this and thinking this is exactly the kind of reporting that cuts through the noise and tells you what actually matters, then subscribe right now. Share this with someone who needs to hear it. This channel doesn't do performance, it doesn't do theater, it does accountability. And right now, in 2026, accountability is the single most valuable thing in American journalism. But here's what will not go back to the way it was. The Supreme Court has now formally, publicly, with a 7-2 supermajority that crossed ideological lines in ways the political media is still struggling to fully process, declared that using nationwide injunctions as a tool of political warfare is constitutionally illegitimate. That declaration changes how lawyers advise their clients. It changes how advocacy organizations build their legal strategies. It changes how federal agencies calculate risk when they issue new rules and directives. It changes how states think about the legal exposure they face when they pass controversial legislation. The entire strategic calculus of American legal and political activism just shifted, and there is no honest legal professional in this country who would tell you otherwise, regardless of their personal politics. And there is a deeper implication here that deserves to be stated with the clarity it almost never receives in mainstream political coverage. For years, honestly, for decades, both political parties have been quietly, comfortably, conveniently dependent on a federal judiciary that had accumulated power it was never constitutionally designed or intended to hold. Not because the judges were corrupt, not because the lawyers were evil, but because it was useful, and because it meant you could achieve national policy outcomes without doing the grinding, unglamorous, perpetually frustrating work of building democratic majorities. You could change the country without convincing the country. You could win without governing. You could bypass the messy, slow, accountability-laden process of actual democracy and still get the outcome you wanted. As long as you had good enough lawyers in the right courthouse, the Supreme Court just closed that exit. 7 justices, conservative and liberal, appointed by presidents of both parties, shaped by fundamentally different judicial philosophies, looked at where American democracy had drifted and decided together that it needed to be pulled back toward what the Constitution actually created. A system that is harder, a system that requires more from elected officials, more persuasion, more coalition building, more genuine accountability to the voters who put them in office, a system that demands more from citizens, more engagement, more pressure on their representatives, more willingness to show up and fight for what they believe in through the democratic processes that actually exist, rather than hoping a sympathetic judge in a favorable jurisdiction will do the act. Work for them, a system that cannot be shortcut by whoever has the cleverest legal theory, the most money, and the most convenient courthouse. That system is messier, it produces slower results. It will frustrate people on every side of every debate at various points and in various ways, but it is unambiguously more honest, it is more legitimate, it is more faithful to the democratic promise that every generation of Americans has been handed and asked to honor and pass on. The court can draw a line. It cannot force anyone to respect it. It cannot force elected officials to do their jobs. It cannot force political parties to abandon the shortcuts they've relied on for so long. It cannot force citizens to stay engaged and hold their representatives accountable when the daily noise machine is working overtime to keep them distracted and exhausted. That part is up to you. That part is up to the voters. That part is up to every American who is paying attention right now and deciding, consciously or not, whether self-government is actually worth the effort and commitment it genuinely requires. The Supreme Court's 7-2 emergency ruling on nationwide injunctions is a turning point. Not because it solves every problem, not because it ends every fight, not because it makes the path forward clean or easy or painless, but because it forces a country that has spent years outsourcing its hardest, most consequential political questions to courtrooms to confront those questions where they were always supposed to be. Confronted in legislatures, in elections, in the direct democratic engagement of a self-governing people who actually believe that what they do and who they vote for and what they demand from their representatives genuinely matters. That is the full weight of what just happened. That is the story the establishment hoped you would sleep through. You didn't sleep through it. Now make sure someone else doesn't either. Share this. Drop a comment telling me which policy arena, immigration, guns, elections, environment you think will be transformed most fundamentally and most rapidly by this ruling. And if you believe that real journalism means telling people what actually matters, even when it is deeply inconvenient for everyone in power, then subscribe right now. Because the stories that change your life are exactly the ones that get buried the fastest, and this channel will not let them disappear.